Baltimore Neighborhoods Incorporated, also known as BNI, is Maryland's fair housing organization that works for justice in housing. It investigates federal, state, and local housing discrimination throughout the state of Maryland. Many individuals with disabilities, their advocates, and medical professionals are familiar with accessibility requirements under the ADA, the Americans with Disabilities Act, but few individuals know about the protections for people with disabilities under the Fair Housing Act as amended. Each year, BNI and other agencies receive numerous complaints of disability housing discrimination. Individuals with disabilities experience a disproportionate level of discrimination in comparison to other protected classes under the Fair Housing Act. So according to the National Fair Housing Alliance, disability-related complaints make up about 51.8% of all complaints received by NAFA members and other government agencies, including HUD.
I moved into an apartment here, and I lived there for a few years, and I was getting weaker in the knees, and I was sick one day, and I wound up with pneumonia and bronchitis. It just was hard for me to breathe, to get up the stairs. It was hard for me to be normal anymore. And it was one day I was going, I don't remember where I was going, but I was going somewhere, and I had put on my clothes, and I got to the point where I walked out my door, locked my door, and I fell down the whole flight of stairs. Basically, that was it. I just fell right flat on my face and on my knees and bruised up everything, and off to the hospital. When I got out, I called to the manager to let them know that I had fell in the building. I said, but I need to talk to someone about getting off of the third floor. I waited, I think, a month and a half, and I didn't hear anything from them. And then I said, okay, I remembered something. I remembered BNI. So I said, oh yeah, let me call.
Unfortunately, denials or delays to requests for reasonable accommodations like Ms. Cynthia are too commonplace. The good news is that the Fair Housing Act provides protections to address these matters. BNI assists complainants with requests for reasonable accommodations from their housing providers. In this particular case, we were able to help assist Ms. Cynthia secure a reasonable accommodation that met her needs.
The Fair Housing Act protects against discrimination in housing based on race, color, national origin, religion, and gender. In 1988, 20 years later, 2 additional protected classes were added. Those are familial status and disability. A disability under the Fair Housing Act means someone who has an impairment that affects their major life activities, such as walking or hearing or seeing or relating to other people. It's something significant.
So a reasonable accommodation is a change to a regular policy or a procedure or a rule that a housing provider might have. So a person with a disability might ask that a rule be changed or applied differently to him or her because of their disability. Under the Fair Housing Act, it's unlawful for a housing provider to refuse to make reasonable accommodations for a person with disabilities. Reasonable accommodations must be paid for by landlords. A landlord can refuse if it's an undue financial burden or it's unreasonable for some reason. So usually that means that it's an undue financial or administrative burden. Other than that, a landlord can refuse to make accommodations when the request isn't related to the person's disability or when the request isn't made by the person with a disability.
In addition to reasonable accommodations, the Fair Housing Act also offers individuals the rights to reasonable modifications. Modifications are structural changes to a dwelling. These are things like installing a wheelchair ramp to an entryway, grab bars in a bathroom, or adding additional lighting.
I moved in probably about 3 years after I was declared legally blind. So when I went to view the apartment and sign the lease, I already knew that some modifications were necessary.
A modification is a change to the structural part of a home or of a rental apartment. For example, someone might request a ramp or request to install grab bars in their home, that the doorways be widened, or that the countertops be lowered for someone who uses a wheelchair.
I actually made my needs known to the leasing office, filled out the appropriate paperwork, and time went by. A month went by, and I revisited the appropriate personnel in the leasing office. 2 months went by. 3 months went by. After 8 months, and me not being able to utilize my living area, my dwelling, I actually sought some help because I knew that this was not appropriate. During the time when I was actually waiting to have the modifications to my apartment, it was very frustrating and actually just another day-to-day hassle. You know, if I'm not here where a lamp is located and I move over maybe about 6 feet to the left, I can't see. So it wasn't my space. It didn't feel like my space because my own home wasn't accommodating my needs.
With regard to reasonable modifications or structural changes to an apartment or a home, the modifications have to be paid for by the tenant under the Fair Housing Act. The exception to this is when there's federal money in an apartment complex. In those cases, another law applies, Section 504 of the Rehabilitation Act. And because there's federal money that is coming to finance and pay for an operating subsidy for the development, HUD has said that those landlords that are federally financed need to make and pay for the modifications on behalf of the tenant. The other exception here is that if a unit was already required to be accessible under the Fair Housing Act, then the landlord's required to make it accessible if it or make the modifications if they haven't already been made.
So one example of a reasonable accommodation is requesting an exception to a landlord's no pet policy. This allows service animals or emotional support animals in the tenant's home. Another example may be transferring from an inaccessible apartment to an accessible one. Common examples of reasonable modifications might include changing a doorknob to a lever or installing a roll-in shower or installing other assisted devices.
When making a reasonable accommodation request, HUD has said that there should be a nexus or a connection between the person's disability and what they're requesting. So if someone is requesting that they, for example, be able to use a different entrance to the building as an accommodation to their disability, they would have to show that the reason for their request is related to their disability.
In order to exercise your right to a reasonable accommodation or modification, it's best to make a written request to your landlord. Make sure the letter includes the nexus or connection between the disability and the request. Second, you may need a medical note from a doctor or a medical professional who is familiar with your disability and your needs.
Well, commonly what would happen is a request will have been made to a housing provider for a reasonable accommodation or modification. It may be denied or the process of approving it is stretched out to some degree that is impacting on the request. BNI would step in and contact the housing provider and say, Mr. or Mrs. Smith is here in our office or has contacted us requesting what we consider to be a reasonable accommodation or modification under the Fair Housing Act. How can we put this into place?
If you're denied housing, you should ask why. You should ask, what's the reason for my being denied housing? And you should ask if you can appeal or if you can give additional information, because that's another type of a reasonable accommodation. So if you're denied housing because you don't have credit, for example, there may be another way you can show that you can comply with your lease and pay your rent on time. Just because you haven't lived in the community, if that was due to your disability, you should get a reasonable accommodation. If you're told that housing is unavailable and you believe that it is available, you have the right to make a complaint. You should also keep track of your interactions with housing providers, to keep track of when you apply, and ask for a denial notice if you've been denied housing. You can also appeal if you've been denied housing and offer to give additional information and ask for a reasonable accommodation request if the reason for your denial was related to your disability.
Reasonable accommodations and modifications can apply to rental properties and subsidized properties. It can also apply to other types of housing such as condominiums or shelters, or even apply to housing services such as sales, lending, or applying to public housing.
I think literally within 2 weeks of BNI getting involved, after 8 months of going through request after request and being put off, I had lighting in my kitchen area under the shelves. I had lighting in my closet. I had overhead lighting in my bedroom area. The work that BNI does not only assisted me on a personal level, but also afforded me the knowledge of how to go about having your needs met, what to do when they're not addressed in a timely manner, and how to also just be an advocate and an agent for change on a macro level.
BNI doesn't just serve Baltimore. We service the entire state of Maryland. You have rights under the Fair Housing Act. If you need assistance with requesting reasonable accommodation or modification, you can call BNI or Disability Rights Maryland. If you feel that you've been discriminated against in housing due to your disability, you can file a complaint with HUD, MCCR, or BNI.